All right, so let's talk about a really fascinating Supreme Court case. It all starts with a simple and pretty noble goal, getting America's schools and libraries hooked up to the internet. But it ends up asking a multi-billion-dollar question. And that is the central puzzle the justices had to figure out. It's a huge question about what really counts as government money. And the answer, well, it could change how we protect all kinds of public-private programs from fraud. So this whole thing kicks off back in 1996 with the Telecommunications Act. That act created something called the E-rate program. The mission was super straightforward: help subsidize internet and phone services for schools and libraries, especially the ones in rural or lower-income areas. Now here's the detail you really need to pay attention to: the funding. This program is not paid for with your tax dollars. Nope. Instead, the government requires telecom companies to pay into this massive fund, and that fund is then managed by a private nonprofit. This unique setup is the critical piece that the entire case hangs on. Okay, so to make sure this giant pot of money wasn't getting ripped off, the FCC put a really simple rule in place. It's called the lowest corresponding price rule. It basically just says that a company, like Wisconsin Bell in our story, can't charge a school getting an E-rate discount a higher price than it would charge any other similar customer. Makes sense, right? Keep it fair. And this is where our whistleblower says things went sideways. An auditor named Todd Heath claimed that Wisconsin Bell was doing exactly what the rule forbids: jacking up the prices for schools. And you can see the math right here. If the real price is $1,000, the fund pays out $600. But if the company gooses the price up to $1,500, suddenly the fund is on the hook for $900. Heath alleged this was happening over and over, costing the E-rate program millions. So what does Heath do? He turns to a really powerful and actually pre-old law called the False Claims Act. It goes all the way back to the Civil War, and it lets a regular citizen sue on behalf of the government to get back money that's been stolen through fraud. But here's the catch, and it's a big one. The False Claims Act is specifically designed to protect the government's wallet. For a lawsuit to even work, the government has to provide at least some of the money that was allegedly stolen. So the whole case boiled down to this one question: who really provides the money for the E-rate program? So you can see the battle lines drawn pretty clearly here. On one side, you've got Wisconsin Bell. They're saying, hey, this is all private money. It comes from private phone companies, it's managed by a private company, the US government doesn't contribute a dime. But on the other side, Heath is arguing that because the government forces companies to pay in and basically controls the whole show, it is government money. So what happens when this gets to the Supreme Court? Well, the answer was decisive. They sided with the whistleblower, Todd Heath. And it wasn't even close. The decision was 9-0, unanimous. Right, but a 9-0 decision on something this tricky? How did they pull that off? This is where it gets really smart. The court didn't go for the big, sweeping answer. They didn't declare that any government-mandated fund is automatically public money. Instead, they found a very specific, almost surgical reason to side with the whistleblower. And that specific reason comes down to this number right here, $100 million. See, it turns out that during the years the fraud was allegedly happening, over $100 million flowed directly from the U.S. Treasury, the government's bank account, into the E-rate fund. And that fact changed everything. So you might be asking, where did this $100 million even come from? It wasn't just pulled out of thin air. About half of it came from the government chasing down phone companies who were late with their payments. The other half? That came from settlements and restitution after the Justice Department went after other companies for E-rate fraud. So the government wasn't just a bystander, it was actively generating and collecting these funds. And this was the key for the court. They said, look, the law says the government only has to provide any portion of the money. That $100 million from the Treasury, that's definitely a portion, and because the government supplied at least that piece of the fund, the entire program was fair game for a lawsuit under the False Claims Act. Justice Kagan, who wrote the opinion for the whole court, came up with this fantastic analogy to nail the point home. She said, think about a proctor handing out exam books. She didn't buy them, but she's still providing them to the students. In the same way, by collecting that $100 million and directing it into the fund, the government was providing it. It's a simple but really powerful way of looking at it. But here's the thing. By being so precise, so surgical with their ruling, by focusing only on that $100 million, the court basically kicked a bunch of bigger, trickier questions down the road. For example, they never actually answered the big one. Does just forcing companies to pay into a fund count as providing it? They didn't touch the issue of whether the private company running the fund is technically a government agent, which, as Justice Thomas pointed out, could open up a whole other can of worms. And they left the door open on how damages should even be calculated. All of this pretty much guarantees we're going to see more legal fights over programs like this in the future.
Okay, so after all that, why should you care about this case? Why does this whole thing about phone bills and school internet matter? Well, the impact here is about way more than just one program or one company.
For starters, this is a huge deal for whistleblowers. It really strengthens their hand when they go up against fraud. Second, it makes it clear that these kinds of quasi-public funds, the ones that live in that gray area between private and public, still get fraud protection. And finally, it sends a really strong signal. If the U.S. Treasury so much as touches a piece of the money, federal fraud laws can apply to the whole pot.
So, while the court's decision keeps the E-rate fund safe for now, it leaves us chewing on this really big idea. We're seeing more and more of these public-private partnerships, and this case forces us to ask, where's the line? How much government control or how much government money does it take to turn what looks like a private fund into a public trust that deserves our strongest legal protection?